Thanks, Angela. Good morning and welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. Angela, can you take the roll?
Yes. Ali,
Present.
Brown,
Present.
Coleman,
Present.
Chivers,
Here.
Guzman, Krieger, Mercado,
Here.
Mohebi, Munoz, O'Reilly,
Here.
Poindexter, Ravi, and Riley.
Here.
Thank you.
Thanks, Angela. Now we're going to call for public comment. The State Bar will attempt to call members of the public in the order that they appear in the attendee pool. And I think we've got somebody in person. So Angela, can you go ahead?
Yes. For anybody participating in the attendee pool, if you could use the raise hand function at this time to indicate if you'd like to give a public comment, I will call on you in the order that your hands are raised. We do have somebody in person, so I will be turning my laptop to him. Please. One moment, please. So it'll be 3 minutes. Okay, are you ready?
Yes.
Okay.
Good morning, Chair and all members. My name is Kai On from Sacramento. In 2023, Sacramento District Attorney Office provided me fake information. DA case number 99F08735. Jung Soo Fong killed my father Woon Kong On and was sentenced for 11 years. I have emailed Sacramento DA office and mail letter and complaint form many times, but Sacramento DA, Mr. TNO, has never responded since January 2024. I have filed 6 complaints since February 2024, but Attorney General's office did not respond. I don't know which attorney in the office is covering up my complaint. I ran into Attorney General 2 times at 2 public events at Sacramento in January this year, but Mr. Robert Bonner refused to take my complaint letters. I also filed complaint to grand jury, but no response. I went to Sacramento Superior Court 2 times to submit complaint letter to presiding judge about my complaint submitted to grand jury. I also contact Judicial Council and Commission of Judicial Performance. Civil Rights Department does not handle my complaint. I have filed complaint to State Bar of California about Attorney General, Sacramento District Attorney, and Sacramento Superior Court presiding judge. Please look into my complaint because many licensed attorneys in Sacramento City government, in Sacramento County government, and in California state government are involved in covering up the truth of my father's death. As of today, I still don't know who killed my father, Woon Kong On. I did email this Sacramento DA handwritten note to this committee before the meeting. And also this is the letter that from State Bar of California for my campaign of Attorney General's campaign of Sacramento District Attorney and campaign of Sacramento Superior Court presiding judge. Thank you, everybody, letting me to talk about my situation. Thank you.
Yeah.
And thank you, Angela, for helping.
Thank you, of course.
Thank you.
All right, as a reminder, everyone's going to have 3 minutes and I'll give you a 30-second warning. The next public commenter is Benjamin Sailheimer. Benjamin, your mic has been enabled.
Oh. Hi, can you hear me okay?
Yes.
Hi, my name is Benjamin Seilhammer, and I work with Genesee Center. Today, I address this board on behalf of California service providers for victims of domestic violence, as well as on behalf of domestic violence victims themselves. I implore this board to join us in advocating for an amendment to the California Rules of Professional Conduct, specifically Rule 1400, regarding advertising and solicitation, to absolutely prohibit attorneys from soliciting by any method respondents named in temporary restraining orders. To this day, attorneys have been able to solicit violent abusers in order to sell their services while simultaneously jeopardizing the physical and emotional safety of their victims when they are at their most vulnerable. This permittance has already caused real harm. On multiple occasions, lawyer solicitation has caused domestic abusers to discover that their victims had filed a restraining order against them before the abuser had been served with the order. During this window of time, which constitutes the period immediately after the victim files for the restraining order, and right before the domestic abuser is served with the order, is when the victim is at the most vulnerable to the domestic abuser's most egregious abuse. This is because, one, domestic abusers get more violent after their victim tries to escape them, or two, or stands up to them, and two, the restraining order is not yet in effect, so the domestic abuser is not yet legally restrained from the victim, and the abuser's firearms have not yet been confiscated by law enforcement. On one tragic occasion, shortly after a yet-to-be-served domestic abuser received a lawyer's solicitation, he shot his victim to death. On another occasion, a yet-to-be-served domestic abuser was notified of the restraining order through a lawyer's solicitation and then ran over his victim with a car, causing great bodily harm. As Californians, we are all lucky, that the board members before me hold in such great value the ethical practice of law, as well as regulation that intends to protect the public. As such, I again implore the board before me to join us in prioritizing advocacy for amending the California Rules of Professional Conduct, specifically Rule 1400 regarding advertising and solicitation, to absolutely prohibit attorneys from soliciting by any method respondents named in temporary restraining orders. Thank you for your time.
Thank you, Benjamin. Our next public commenter is Minty Sue Kutnikov. Minty, you may begin when you like.
Hi, my name is Minty Sue Kutnikov, and I'm an attorney in California. I've been practicing in California since 1995, and I have a background in domestic violence. I started working with the Asian Women's Shelter in San Francisco and API Legal Outreach, which used to be Nihomachi Legal Outreach for the San Franciscans in the audience. And I am currently the Legal Services Director at Sojourn, the second oldest domestic violence shelter program in California. I am speaking today. I have already submitted a written public comment, but I'm speaking today because I agree with Benjamin that I want to bring your attention to a troubling and dangerous practice that's been become increasingly common as attorneys become more aggressive in soliciting business from the public. The practitioners in my field know that the most dangerous time for a victim of domestic violence is when she's leaving a violent relationship, when he or she is leaving a violent relationship, and that 75% of domestic violence homicides occur after the victim leaves or makes clear that the relationship is over. Thus, filing a domestic violence restraining order can bring great risk and threat of death to someone who's made that decision to file a restraining order. And we know that that restraining order, even though it, offers this hopeful promise of protection, can be the most dangerous thing a victim does because it signals to the abuser they're leaving, and that's what triggers the violence. So it's really appalling to me that attorneys in this attempt to solicit business, they can go into court files and they can review who's got an upcoming court file. Let me target them for solicitation. This was kind of harmless when who they were targeting were people who were defending eviction cases or people who are just in your run-of-the-mill divorce. But when it comes to targeting people in domestic violence restraining order cases, that can be notification to an alleged abuser that the victim's trying to get away. And that will trigger the abuser, the alleged abuser,
30 seconds.
that they are going to want to claim power over the victim. So it is highly dangerous, these solicitations. We know they're immoral. We ask that the state bar make them also unethical. So please modify the rules of professional responsibility. I beg of you.
Thank you, Minty. Is there anybody else who would like to give a public comment? Please use the raise hand function at this time. Okay, I don't see any other public comments.
Okay, thanks, Angela. Thank you to the public commenters. We're going to move on to the approval of the minutes from the last meeting. Are there any corrections or modifications to the open session minutes? Nope. No corrections or modifications. Can I have a motion for the approval in a second?
I will move for the approval. The minutes, please.
I'll second.
Okay.
Okay, I'll take the vote. Ali,
I'll abstain.
Brown,
Yes.
Coleman,
Yes.
Guzman, Mercado,
Yes.
Mohabi, Munoz,
Yes.
O'Reilly,
Yes.
Poindexter, Ravi, Riley,
Yes.
and Chivers.
Yes.
Thank you. The motion carries.
And briefly, I'll just note, Mary Grace, you abstained, is that correct? Thank you.
All right, thanks, Angela. Now next is the chair report. I really don't, I don't have anything on my report other than I think we're going to have a quick meeting and hopefully we'll be voting out some opinions. So let's move on to the staff report.
Thank you, Cassidy, and hi, everyone. Good morning. A few items that I will be brief on. First of all, the State Bar staff that you're seeing on these meetings continues to grow, which is really exciting. We're kind of in the waxing portion of this. And then we will be kind of reducing our staff that's supporting COPRAC eventually. But as part of our growth, I'd like to introduce very briefly Karen Garcia Vargas. Karen is with the Office of Professional Competence, and she will be cross-training, or has already been cross-training with Angela to support the committee. So Karen, if you want to introduce yourself.
Hi, everyone. Like Erica said, my name is Karen Garcia Vargas, and it's been a pleasure to be joining the committee with COPRAC. It's exciting, and I look forward to working with all you guys soon.
Thank you. And I believe everyone has already met Kathy Ungary, who is the new program director of the Office of Professional Competence. But for those, I just wanted to make a note of that. And Kathy, since you introduced yourself last time, I'm going to let you off the hook this time, if that's okay. Great. Okay, so 3 brief committee related updates. As a reminder, there are 2 items that are currently out for public comment. Both of them will be ending on April 15th, so about a month to go here. The first is the proposed amendments to the Rules of Professional Conduct, specifically Rule 8.2 and Rule 8.4, related to threats against judges. Those were voted out by the committee at the last meeting. Additionally, the proposed formal opinion 20-0001, which is lawyer as expert witness. Regarding the rules of professional conduct, we have received a few comments from attorneys so far, kind of on both sides of the proposal, but nothing yet from stakeholders that I'm aware of. And then related to the formal opinion, I don't believe we've received any comments yet on that opinion. As far as updates and future events, a reminder for those of you who are not getting a lot of emails from Angela that the Ethics Symposium will be on April 25th. Thank you to our moderators who have been very responsive to those emails that you have received. And we'll talk about the symposium more substantively later on in the agenda today. And then one last reminder, our next COPRAC meeting, we have a bit of a gap here because of the symposium. So 2-month gap, which will, I'm sure, come up quickly, but is the longest gap I believe that we have between meetings. So the next meeting will be May 9th. And just a reminder, that is in person in Los Angeles. So shortly after this meeting, we will be sending a reminder and information as to how to book your travel. You can still attend remotely, but we of course encourage everybody to participate from Los Angeles if feasible. And I believe that's it from me. Thank you, Cassie.
All right, thanks, Erica. Okay, so let's move on to business. I think were we switching 4.1 and 4.6, the client file release and ethics of in-house counsel? Is that right?
That was the plan, but Mary Grace, I see you here. So do you want to take that one up first since you're on?
Oh, you're on mute.
Yeah, it's up to you. I can be here until about 11 or so.
Sorry, I just have a mandatory training that I'm giving a new person on our team.
Well, it's up to you. If you think you can get it done now,
So,
then shoot.
yeah. So I've reviewed, and what my goal is I know that when we started talking about this, I guess a year ago, we wanted to have a focus group and get input. So I've identified essentially 3 groups. I know we wanted to get one, retired attorneys or about to retire attorneys, to get their sense of what are they going to do with all their records, because that's a big concern for a lot of people. So I've identified folks and asking if they're interested. I have also identified I would like to get input from smaller law firms, just to get a sense of how are they going to deal with all this information. I know that it's also becoming an issue for, like in my case, larger law firms, where corporations are now having document retention guidelines within their OCGs. So my thought is that I'm hoping to get people together and organize the focus groups that we had previously talked about the week of like the first week of May. And so I was wondering, is it Angela that would help, or is it you, Erica, that would help organize the focus groups? I have identified folks. I'm starting to ask around to get a sense of interest, and then we can hopefully get everyone chatting together and get a sense of their thoughts and how to maintain these documents.
As far as coordinating people, that would be likely Karen and Angela, but we can certainly assist with that.
Okay, perfect.
Okay. Anything else? So the plan is that you're gonna get more input from, the interested
Stakeholders.
parties. Yeah,
Mhm.
and then we'll revisit this at the next meeting, which is May 9th.
Yeah.
So
So I would
probably not until the meeting after that then.
Yep.
Okay.
So Chair, if you don't mind, I believe we had asked I'm not sure if it happened, but we had asked the full committee to take a look at that opinion and review the public comments as well, to see if they, based on, I know that some people had reached out to criminal lawyers who are practicing in the criminal defense space already, and gotten some input that while they thought that the opinion would create work for them and costs for them and so forth, they did feel that it was the right result in the opinion. And so I believe what had been intended today, and Mary Grace, I apologize if this wasn't clear, but for the full committee to discuss if at this point they thought that the opinion should move forward to adoption and be reissued for public comment. Certainly we could do neither of those things today and wait for this focus group that it sounds like Mary Grace is already certainly working on moving forward with. So I just wanted to tee that up, because I think that was part of the discussion at the January meeting.
Well, who's on the working group? We've got Emil and Eleanor and Brandon. And why are there so many people in the working group?
I think some of it is historical, because it's been around for so long.
Right.
So this working group was, I believe, reformulated back in December or so, because at the time it was just Brandon who was left on it, or maybe farther back than that. But it was originally, for those of you who recall, it was originally the lead was an individual who was a district attorney, and that person is no longer with the committee. And so then it was just Brandon, and not a lot happened at that time with the opinion. And so that's kind of, we expanded the working group. I want to say it may have been 6 months or so ago.
Okay, so do we have any input from the working group about, did anybody go back and review the public comments and the input by the criminal law attorneys? Is there any input one way or the other whether or not we should vote it out, or or wait on the focus groups that Mary Grace is talking about. Eleanor, I thought you.
Yeah,
Sorry.
I came off because I didn't know. It's fine. I haven't yet looked at the public comment, in part because I thought we were moving forward with focus groups at some point, and would delay it until then. I'm in favor of focus groups if we have good participants. I think it's an important issue and we should hear folks out. But if we can't get participants, then maybe it's not necessary. I don't know how robust the comment is. It sounds like it's fairly light.
It was. And so I think that was kind of the sense, is that this opinion has been around for quite some time now. It hasn't been out for public comment in quite some time. And so I believe the committee was in part thinking, had a sense that maybe it should be reissued and we could do some targeted outreach in public comment. So that it went to more defense practitioners and others. So that could happen now, of course. Or it could happen after there's been these kind of focus groups as well. And if you issued it now, you could certainly get the input of those individuals in that
On the
format
comment.
or otherwise. Yeah.
I
Yeah,
like that
I'm-
approach. That makes sense to me. I think that would be good to get it moving. It
Yeah,
might be
thanks,
beneficial to
Erica.
have more comment.
Yeah, I think I mean, so can we do just this two-pronged approach where we are going to just put it out and target the people we want to comment? So in the introduction paragraph of the request for public comment, and then also the focus groups that Mary Grace is talking about, so that we get this ball rolling. And then by the time, if we put it out for public comment now, we'll have them by the next meeting. So it'd be like a 60-day public comment?
So a 60-day, it wouldn't come back until not the main meeting, that's just fine. I think if you did a 60-day, you'd still want to give the working group some time to turn it back around. And I'm trying to find when our next meeting is thereafter. It's August 1st. Or actually, I apologize, there's a June meeting, I believe. So it could come back at the June meeting or the August meeting.
Okay. So Mary Grace, what do you think about that timing and the process?
That works perfectly. And then, like I said, we can then get, like I said, a smaller focus group, and then hopefully we can also look at the specialty bars and see if maybe like the criminal specialty bars would be able to review and get their input too.
Okay, so we'll put it out for public comment. It'll come back, in June. We'll have the focus group and specialty bars input by then. And then, assuming we have our revisions, we'll probably have to issue it out again for public comment, right? Yeah. Okay, so do we take a vote on we take a vote on it being, any other comments or input or thoughts on this opinion and approach? Oh, sorry, Raquel.
That's fine. I have a question. Good morning, Akita. Mary Grace. So did I read correct? I did read the public comments. I did think they were thoughtful. Did I understand though that they're from 2022? Is that correct?
Yes, they are nearly 3 years old at this point.
Okay. And then the second question, can you just restate, Mary Grace, who you are intending to be in the focus group? Categories of who?
So because of the fact that this especially heavily impacts lawyers who are either retiring and criminal law attorneys, because you can't destroy documents after the 5 years if you are representing a defendant. It's supposed to be forever, really. And so we want to get their input is for the smaller law firms. How are they going to maintain these records? How are they going to deal with the documents? Because document retention is a problem for a lot of small lawyers. It's a problem for large law firms too, because it's just, you create so much data, even like electronic data. So the goal is to get input and get a sense of how they're managing this information. What do you do when you have a criminal client, maybe they're doing life in prison, but you have their records. You're supposed to keep these documents for the life of that individual. And that's a heavy burden for any law firm, but especially those that are smaller law firms, solos who are trying to retire, and what happens to those documents.
Okay, so I think you're saying the focus group, so I understand the issue, but I think you're saying your focus group primarily is going to be criminal defense attorneys in smaller firms. Is that your target? Yes.
Yes, exactly.
Okay. All right. I will say I did note that there seems to be a natural overlap with the opinion on succession, because that does also seem to have been brought up a number of times. So I just mentioned that it seems like whatever we said over there about succession and whatever we're saying on this opinion, there should be an intentional integration. Sometimes we do these opinions as transactions and they don't necessarily connect. So that was, I think a number of people made that point, and I thought that we could improve there.
You mean cross-reference the succession planning opinion with this opinion?
Well, I don't necessarily know I don't know what it says because I don't necessarily remember, but what I'm saying is this group should look at whatever it is saying in that opinion and see how would they, if necessary, to say something, or perhaps it means going back and looking at what we said. Because
so that's consistent.
Yeah, and that it's, to me, I felt like the succession planning one was light. It was sort of light on the way it was done. It seemed at the time to be like, oh, well, that's not really important. That'll take care of itself. But it seems like this is an area that it might not take care of itself, which it seemed very obvious that could definitely happen when you're talking about the holding on something for the life of someone.
Yeah, or like,
so I'm just pointing it out. I think they should look at that other one, and they'll decide whether they may come back to the committee and say, hey, we think we need to go back and do something with that one, or that one's fine. We just want to add X, Y, and Z. Make sure we add the idea of succession more explicitly, because that was mentioned.
yeah, I think that's a good point, because especially when you're just closing your office, and I can't remember if the succession planning opinion talked about that. So I would, yeah, I agree with that. And I think that the committee should, the working group should look at that issue. Anything else? Nope.
I just want to wrap it up so we can get this moving. So we want to, with regard to succession planning, we want to either incorporate it or have reference to the succession planning opinion. Is that
well,
correct,
I think
or do you want it to be more robust as it relates to succession planning?
My comment is really for the working group to take that into consideration, and you all make the determination of given what you're trying to achieve, what is appropriate. So my recommendation is just to look at it and decide. Nothing more specific.
Erica?
So not to slow this down, but two thoughts here. So it could either it could stay with the working group for a bit here and address those concerns that Raquel has raised as far as cross-referencing the succession planning opinion, pointing out that this, because of the perhaps higher instance of solo practitioners in the criminal defense space, that this issue of succession planning, particularly if you're required to maintain files longer than the time that you are going to be a practicing attorney, will come up more. So that could be addressed in this opinion. If you're going to do that, that would be a substantive modification that would be required to go out for public comment. So there's really two options here. Option one is issue the opinion as currently drafted for another round of public comment. We could tee up the fact in the public comment memo that there will be changes to the opinion to address succession planning vis-a-vis file retention. Or you could make those edits now and then issue it for public comment at the May meeting, or, you know, at some point, and incorporate, you know, get the focus group feedback, etc., and issue it with the thought being that if the public comment does not require substantive modifications after that, then it could just be adopted. So I think you could face needing to do public comment again either way, of course, but if that's already incorporated, it's not certain.
Historically, what have you noticed, have you seen is most efficient, I guess is the question.
I mean, we usually try and do the best version. I think it's a little bit, this is evolved to some extent. We used to try and do what we thought was the best and final version of an opinion and issue it for public comment in hopes that there would be one round of public comment, modifications, and if needed, an adoption. The committee, and perhaps because we're addressing issues that touch on particular practice areas, so criminal law, in-house counsel, and so forth, nearly every opinion as of recent times has required at least 2 rounds of public comment. That's not to say I don't still think the best and final version should go out for public comment in round 1. This one's already been out, so this is round 2, and then it would be round 3. This is an incredibly important issue, though, for practitioners. So I do think getting public comment is certainly a positive thing. I just it's really the will of the committee to decide what makes the most sense for them right now.
I think we have a specific purpose, though, or kind of a more of an somewhat unusual purpose for putting it out for public comment now, because we are eliciting, you know, specific comments for input. So we're anticipating substantive changes and another 3rd round of public comment, I think. So I would support sending it out for public comment now, just because we're keeping the ball rolling, you know. So that's my 2 cents. Anybody else?
I agree with that, partly because it's not totally clear to me what the solution is if you're supposed to keep these forever, but you're retiring or you die. If the state bar wants to build a warehouse somewhere, you know, we can mail this stuff to you, but I don't see that happening. So what is the solution? It has to be analyzed ahead of time, obviously.
There is a mechanism that the state bar has when they assume jurisdiction over a deceased or declining attorney's law practice, and they do have a method for storing and retaining files, and they treat civil files differently than criminal files. And maybe the onus is on the bar if they're going to implement this requirement. Maybe the onus is on the bar to allow attorneys to lodge their files with them when they retire, if the requirement is the life of the client and not the life or the working life of an attorney.
Yeah, I think that, so if that procedure is the one, then we should reference it, but also maybe there are other ideas we would get back in public comment that would be useful for people who have actually gone through that, if possible. I'm going to take a wild guess that that's probably not the most efficient thing in the world, but maybe it is.
Assumption cases are like less than 20 a year as well for really egregious cases with client harm.
And I did most of them for like 4 years.
You did that, okay.
Yeah,
Yeah.
no, and it was, and actually, I mean, the state bar is really well resourced to handle them, and has, I thought, did a very good job with winding down practices, and then also assuming jurisdiction over, you know, unlawful law practices. But for the ones of attorneys that were deceased or declining, I believe that the state bar handled them very well.
Yeah, it might be a question of volume. So if we have a new requirement, or we clarify that the requirement is you have to hold on to this forever, if I'm going to retire, then I'm just going to put the stuff in boxes and send it over to you. Good luck. So the volume of those isn't going to be 20. It's going to be more like 2,500.
Isn't there also, when you're a corporate attorney and you receive like certain documents for a corporation, isn't there a way to lodge them with the state? Isn't there something like if you receive those, like, I don't know.
Well,
I'm
there
not-
is with the probate estate planning documents, I think. I don't know about corporate docs. Don't we have corporate lawyers here somewhere? No?
I'm not.
No, I
Not that
know
does that.
money can escheat to the state, but
Money can, yeah, but that's a whole thing.
Yeah, not
Yeah.
document.
I mean,
No, but there's like some document that's really important for a corporation that like sometimes gets lodged with the state if they
But you
can't.
have to file, I mean, when you form a corporate, like you have to file your article, but like as far as, I mean, you don't even have to file your partnership agreement if you're a partnership, so
But I
I'm
think
not aware.
getting
I
the
mean,
public comment back will be helpful for the working group to determine whether there are any practical guidance they can give. The rule is the rule, so maybe it's up to every individual who's retiring or dying to figure it out. But if we get public comment that says these are the issues, it might help guide them to make practical recommendations.
and we're assuming that, folks after 2019 have something in their agreement that talks about, what they will keep and won't keep. And then, many people prior to that time may have already had that. So I think the problem may be acute for some people, but maybe not everyone. And I think there's quite a few voices that are voicing the problem that there's this interim period where there might be some folks that have hundreds of files, or maybe they've already destroyed them. But like, it's not the bar that's doing this, right? The legislature done this, and now I think we're supposed to give guidance on the issue. So
yeah, I mean, I get this question a fair amount with retiring attorneys. And it's usually, if you're going to destroy a file, you need to get consent from the client. So yeah, I mean, it is definitely a topical issue, especially with so many lawyers retiring.
I think
and
the
dying.
solution is, Carrie, put your office email in the chat and we'll just have them send them to you if that's okay.
Good idea.
Okay.
So the memo, the memo for the public comment will also reference then this, seeking input on retiring attorneys and what to do with files when you're no longer practicing law. In addition to the specific practice areas that we want information from. Okay. So, are we all are we going to, so we're going to do a vote on whether to vote it out? Oh no, I'm sorry, Novella, I didn't see your hand. Go ahead.
No worries. For the specific practice areas, I'm just remembering that some of the comments distinguished within practice areas, like for the criminal defense versus public defender versus like private court appointed attorneys versus I guess defense counsel who the criminal defendant retains. So there's like an actual retainer that could plan that stuff in advance. So I'm wondering if the target to practice areas can also target within the practice areas based on the appointment type for criminal defense attorneys.
So we can break it down in the memo a little bit more.
Yeah.
Okay.
And then there was one comment raised the immigration issue. And I know a lot of public defenders reach out to like a special counsel to do like the Padilla attorney advisements, like Immigration Resource Law Center does that service for a lot of public defenders in California. So I imagine folks from the attorneys from the immigration space might be a subgroup that has like more particular advice about retaining files for criminal defendants who aren't US citizens.
Yeah, that's a whole other, it's a very specific, but also critical topic. So Mary Grace, do you want to draft up a memo or have the working group draft up the memo, or Erica? I mean, I think,
Yes,
yeah.
They certainly can, but staff normally drafts the public comment memo. It's pretty succinct, I'll just say, because for those of you who haven't reviewed it, it's posted as part, it's not really a memo in the sense that it's posted on our public comment page for that particular item. So it's a couple paragraphs normally. What we would be doing likely is as far as our outreach, we normally, we certainly send things for public comment to the people who have signed up to COPRAC to receive public comment. In this instance, we would be expanding that. So we would be reaching out to organizations, public defender organizations, other criminal defense organizations. It sounds like based on Novella's feedback, in immigration, professional organizations, those types of areas. And then certainly, if any of you have contacts in any of these spaces, I would encourage you to, reach out to them as well, because that's going to be more effective than the general email from the State Bar.
Okay.
But I could certainly, back to the memo, we could certainly, give it to Mary Grace or the working group and let them review it if they're interested before it's posted. Just with the hope that it would come back to us quickly so we can get this posted.
Also,
Yeah, I mean, I just think we just want the input from the group then to be put anyway. I'm just trying to figure out how best to facilitate the getting the input that we're having here into the memo, whether it's staff or Mary Grace to draft it up. But I'll let you guys figure that out. Somebody else was talking.
I was just going to say the other group, because for example, the Contra Costa Bar Association has a senior section. So it's specifically for those attorneys who are preparing to retire. And so maybe we also, we can ask those specialty subsections to review and speak.
Yeah, I mean, have them do a public comment, I mean, and, get together and review it. And yeah, I think that's really a good way of going about it. Okay, so anybody else? Any other input? So should we vote it out or not? Or take a vote whether to vote it out or whether to put it out for public comment?
I vote to put it out for public comment.
Well, we need to.
Is that a motion, Mary Grace?
Make a motion. Sorry.
Yes, it's a motion to
get used to this by now.
Yes,
Is it
second that motion?
Sorry, is there a motion to vote it out?
I make the motion to vote it out.
Is there a second?
There's a second.
Okay.
Okay, taking the vote. Ali,
Yes.
Brown,
Yes.
Coleman,
Yes.
Guzman, Mary Grace.
Yes.
Thank you. Mercado,
Yes.
Mohabi, Munoz,
Yes.
O'Reilly,
Yes.
Poindexter,
Yes.
Ravi, Riley,
Yes.
Shivers.
Yes.
The motion carries. Thank you.
Okay. All right, let's go to the next item. So we're going to do the 24-001 Ethics of In-House Counsel. Let's see, Emil is taking the lead.
Yes, thank you so much. So I think everyone has had a chance, hopefully, to look at this. Thank you to Cassidy, first of all, for the draft that we were put together, and then thank you for the rest of the team that worked on it. I think that we have a pretty good draft. The only thing that we don't have is a good title. So if anyone has any thoughts about that, but I happy to answer any questions, but I think ultimately the goal is to put it back out for public comment.
I had, go ahead. I just had one, and I'm trying, I can't, I've got too many windows open. One kind of substantive comment and a couple of just minor things. Sorry. Okay, Angela, can you scroll down to okay, wait, stop. I gotta find, so okay, keep talking. I'm gonna find my draft. It's just somewhere buried here. Just give me a minute because I can't.
So just for background, it's about, what happens when in-house counsel moves from one company to another. The opinion discusses that it's not an economic conflict to go between economic competitors, and then it highlights the 1.9 analysis, same or substantially related matter. There's discussion, obviously, of the Rule 1.9 issues and imputation rules under 1.10. We also talk about the playbook issue and how California law doesn't prohibit, somebody just to have general knowledge of general business practices or philosophies. And then there's the Ferris analysis in there as well. So, but Cassidy, do you remember like what the substantive issue was?
Yeah, okay, I found it. So the starting at 94. Oh, there you are, you're right there. So what you're talking about there is what are you talking about there is, oh yeah, the personal representation. Hold on, let me think for a second. This is true. Okay, so the sentence for purposes of analysis of conflicts under paragraph A. Wait, let's go to the sentence before that. No lawyer was a part of a team advising concerning its technology and patent. Lawyer advised old company on labor employment. That's similar to a law firm who worked in a particular practice group and was not involved in representing firm clients on matters handling different practice groups. Okay. So for purposes of analysis of conflicts under paragraph A, this is true even if lawyers' advice to and representation of old company likely related to employees who worked on old companies' technology and patents. So I think my comment here is why? And I think this is something that I wrote, but I'm wondering if that needs to be fleshed out a little bit more.
So if lawyer was a labor and employment lawyer who advised the employer regarding employees who worked on the company's IP portfolio, that would not necessarily pose an automatic conflict. That is not the same or substantially related matter, like giving HR advice. Maybe it's just the choice of wording that we use, like the word employees could be changed. Is that? But yes, I believe this was your original, but I understood that that's what you meant.
Yeah. And I'm kind of thinking, like when I was going through it now, I mean, does anybody else have any confusion there, or is it something that I'm
Can we scroll down a little bit so I can see the entire context?
Would it be scrolling back up, Eleanor?
Yeah, sorry. Yes.
Okay, maybe you can zoom out a little bit, and to get it all, or just do paragraph spaces to get it all on the same page.
Oh, okay, yeah. So So the issue, so if the lawyer represent only, even if the lawyer advised employees on provided HR support, HR advice, to employees that were dealing with the company's tech and patents, that's not enough to rise to the level of a personal representation. And that's because there's no, meaningful, it's too remote, right? Unless there's confidential information, which is the next sentence, and that kind of goes to the other prong, more than
Doesn't
this one.
the substantial relationship test still apply there? Wouldn't that be the way it gets knocked out under that scenario? Or am I,
Well,
no?
You mean same or substantially related matter?
Yeah, it's not, I mean, if it's not the same or substantially related, is playbook even relevant, or is anything like, it's totally different type of matter. It's a former client.
So I think we talk about that on the prior page. Or like prior section.
But playbook is accounting for the fact that you can have confidential information that is relevant to a matter, even if it's not the same or substantially related. It's under, if you look at 1.9, there's B talks about substantially related, and then C talks about, well, even if it's not substantially related, their litigation playbook so well that it's still going to be a conflict, even though it's not falling under the same or substantially related test.
Got it. So isn't there a prong under there, though, that there has to be some sort of overlap in subject matter? Maybe it's not the substantially related test, but isn't there something in that analysis where there has to be a relationship between the nature of the matter so that the playbook would be relevant? It just strikes me as a reach to think labor and employment advice would be in any way.
No, I mean, that's the point of the playbook. That's the whole point of the playbook prong, is saying, you know this entity so well, you know so much about their litigation strategy, you're like a coach, you know their playbook, that even if there is not an overlap of subject matter, you have information that's going to be advantageous to the adverse party, that's against your former client.
I appreciate that. And I haven't looked at playbook in a really long time, but I thought there was something there where a relationship of some sort was needed, like to prove that the subject of the playbook would be similar to the subject of the new matter. But maybe that's not true in California, or.
Yeah, so in California, a general playbook conflict is not applicable. There you have to make a connection that playbook. So here, and that's discussed on page 5. But
okay, I think that's what I'm looking for, is because that would seem to easily knock this out under most circumstances, I think. So it was just struck me as strange that we're jumping to what was the level of participation versus is there any connection?
Sure, and one way to look at this would be, so in patent law, the applicant under the AIA is not necessarily the inventor. Like a company isn't the applicant often, right? You have a duty to assign under your employment agreement, like work product for hire. So inventor, comes up with some invention, but under the labor and employment, like lawyer's perspective, they drafted a assignment and employment agreement that says, 2 years ago said, hey, when you start working for us, everything that you create has a duty to be assigned back to the employer. Just because that lawyer worked on that agreement that caused that assignment to take place does not necessarily correlate to being substantially related to the patent portfolio. That I think that was really, and maybe it's not artfully put or explained well enough, and that's why maybe that term likely related to the employees who worked on old company's technology. Maybe we can flesh that out a little bit.
So I didn't mean to throw a wrench in the analysis on this page. I just wanted to point out that it was strange to me that we were jumping to the level of participation analysis as opposed to the connection, but. And
maybe the thought is, maybe this needs to be reorganized. Maybe the paragraphs can be moved around. that's, you know,
Yeah, I mean, I can't recall how the organization came about, but I think it mirrored the ABA opinion. I think, the 99-415, but it does, yeah, it does seem a little bit, well, perhaps same or substantially related needs to go before the A and B analysis, the personal representation, or confidential information. Wait, hold on. No, because B is a subset. Wait a minute. Why is same or substantially related a subset of 1.9B? Acquisition of confidential information. Doesn't same or substantially related apply to both A and B? I'm just looking at this now. Do you see what I'm saying?
It applies
Yeah,
to
I
both
mean,
A and B.
it does say A and B under B. So maybe on line 174, that should be big paragraph C, is that?
I'm just looking up the rule.
A refers to personal involvement. B refers to basically imputed knowledge because of a firm, like it's like the water cooler rule where you weren't personally involved in the representation, but you still got confidential information, but not like true imputation under 110. This is just talking about like you actually got it yourself, but you weren't involved in the representation.
Yeah, so I think this is more of a formatting issue, that maybe instead of being small b on line 174 in the heading, it should be big C, and then the following should be material adversity, could be big D. Is that?
But do we also think that same or substantially related should be first? I mean, now we're kind of just going off script here.
Yeah, so the point is maybe it should be reorganized then, like the.
Yeah. Okay.
I mean, that is kind of the easiest question. So in some ways there's some benefit to having it first, and it's familiar. It might make the nuances you're drawing in terms of the connection later clearer.
Yeah. I think that might be, I just can't remember if there was a reason why it was organized this way. So, but I guess it doesn't really matter if we can make it, if it's confusing, if we can make it clearer by reorganizing it.
Yeah, so I mean, I guess one would be to leave it there and change small b to big C. The other is to move that same or substantially related matters and move material adversity
Yeah.
to the beginning before we get into the discussion of
Personal.
Yeah.
Yeah.
Yeah. So we introduce the topic under big I on line 47, and then we add, you know, I guess it would be a new big A and big B. So I guess maybe the question procedurally, would it be, should we vote to, like, should we make like amendments right now and then vote to approve? Or do we want to kind of all look at this and come up with some edits and then bring it back in May?
Yeah, I think, I mean, I would prefer that. I think, because I think we need to read through it, you know, unless you guys want to read through it and make sure it all makes sense if we're going to reorganize it here. But I think it needs some, more individual focus. I don't know if we're not really wordsmithing. We would be literally reading through it and making sure it made sense. And I don't know if that's a good use of our time here, unless somebody disagrees, especially since this is a pretty complex analysis. But
Might
I
be
do,
something we
so
could bring back after lunch if a group wanted to spend a little time then working. I mean, just as a suggestion, if we thought it was going to be fairly quick, we could consider that.
So,
I mean, that would be fine. Emil,
well,
sorry.
Nikita and Carrie, do you guys have any thoughts? I know, I think Mary Grace is not here right now, but the three of them were working with us on a smaller group, so.
I'm really happy with the substance of this, but I do think we could, we inherited the structure, and I think we all, even when we were working on it, we were a little bit confused by the structure. So maybe if we come up with a better outline and then we can just insert the substance that we've already worked through, I think maybe that would be helpful.
Why don't one of you just reorganize it, read through it, and if it's like, okay, this clicks, then we can talk about it after lunch. If not, you can say it's too much of a heavy lift, and we can work on it. You can work on it separately in the working group and make it. I mean, actually, well, we can vote on this, but I think my preference would be that you take it back to the working group, and for the purpose of restructuring it, not going back to the drawing board on substance, and then bring it back and just make sure it makes sense. That's probably the best approach in my mind. Is anybody else? What do you think, Raquel?
I think we should take it back to the working group. I don't think it's something that can be resolved at lunch.
Okay.
And that was Nikita,
Raquel?
not Raquel.
Yeah, no, but Raquel has her name up.
Yeah. So this was brought here with the idea that we could possibly vote it out for public comment.
Yes.
Is that yes? Okay. So I would be very comfortable voting it out with the provision that the working group will reformat it in the way that's appropriate. So I think it seems like we've given comment. If everyone feels the content is fine, then I think we could vote it out. I think that would be ineffective. I do think they should have the opportunity to do their best work. This will not happen over a break. Over.
So you're saying you think that doing their best work is taking it back to the working group and coming back at the next meeting, or doing it over lunch?
No, mine is saying we can vote it out with the understanding that the working group is going to, before it goes out, rearrange what we've seen here.
Oh,
Because
can we
there's
do that?
Because there's no opposition to what we see here. It's just now it's structured.
Erica, is that a substantive change?
Yeah, I think it would make more sense for it to come back to the committee, because I'm guessing that not everyone will be aligned at the full committee level. Usually when we vote things out, it's just like very minor, but with additional edits to come, it's really like cleanup edits, not big changes.
So that's so just rearranging the paragraphs is considered to be a big change.
Yeah, is that considered a big change? The content is not changing, it's just the order.
There'll be new descriptive headings and that type of thing as well, won't there?
And I can imagine you're gonna have to change. Just that's what I'm saying. Like the flow may need to be addressed, and that will lead to some substantive changes, I think. So, and I just don't know. Looking at it, and I don't know if an hour is going to be enough to address all of that. So, going back to the committee's best work, it's probably not gonna happen today over a lunch break.
I'll
And
just
I
say
don't,
this
and I,
one's- Oh, sorry, Cassidy, I apologize.
no, that's okay. I'm just rambling now. Go ahead, Erica.
I was gonna say, this one actually has moved quickly, so in the sense that I know we're hoping to get things moving forward, but I mean, I do think.
Oh, because it has a 24 on it. Yeah.
Yes, exactly. So, and I think it was a late 24. It was after we decided to split it from the other in-house counsel opinion.
Right.
So I think the working group is working diligently on this, and yeah.
Yeah. So yeah, so there's no, let's just get it right. It's fine. We can come back in May and address the structural changes. I do one other comment I had, Emil, I'm glad you added the comments about the USPTO, the footnotes. I just think that because you have two footnotes, the one about the duty of disclosure, footnote 8, and then the beginning, sort of the qualification that we're not really addressing the USPTO rules. But then you do in footnote 8, kind of. So we maybe just say, but see footnote 8 or something like that. That was the only thing that I kind of caught on. But no, I'm glad that it was addressed. I think it would have been too unwieldy if we had launched a full USPTO analysis with those rules as well. But so I think this was a kind of an elegant way of handling it. But those are basically my comments, and there was like a missing parentheses or something, but that we don't have to worry about that now since we're not. I don't think we're voting it out. Are we going to take a vote of whether or not to vote it out? Or I think okay. Is there a motion to vote it out or not vote it out?
Do we need to do that if the working group has decided it's not ready? Practice, probably not, right?
Okay, right. So let's table it for the next meeting. And then the working group, it just needs to do those final revisions, and then we'll hopefully be able to vote it out next time. Are there any other comments on this substantively before we move on?
I would just ask Emil, you mentioned the title, so are you looking for input on it, or you all, when you bring it back, will be bringing a new title?
I actually don't know how that works. So yeah, if anyone has any input on that.
Oh yeah, it's just in-house counsel draft opinion. Yeah, I mean, it's I don't know. Yeah, we need to come up with a title, right? What are the
I don't put conflicts in there for is it like lateral?
Like ladder what do you former client conflicts regarding in-house counsel or something like that? Because that's the 1.9 rule, right?
I like the conflicts of lateral in-house transitions or something. In-house lateral.
Well,
I'm clearly
mobility I was thinking the term they use, but in-house counsel mobility and conflicts or
in-house counsel mobility. I mean, what about just duties to former clients for in-house counsel or something like that?
It works for me.
We can, I mean, just workshop it. I think we can come up with something by the time we get to the next meeting. Okay. Now, are we moving on? Hold on. Oh, sorry. Okay, I think can we, let's take a quick, 5-minute break. Is that okay? So I need to run to the restroom. And then we're gonna be doing the arbitration advisory. So that's on deck. Okay.
11:17.
Sounds good. Okay, let's move on to the arbitration advisory 22-0XB. Emil and Erica.
I will defer to Erica. I'm happy to discuss, but I'll defer to you.
Sure. Emil, just please jump in if I've missed anything you want to discuss. Okay, so just a little history here. So this was an item that former COPRAC member Elizabeth Bradley was working on, and it was largely to make updates responsive to the Shepard Mullen case. So she did most of the initial edits. It was issued for public comment. We received 7 public comments in response to the opinion. I'm sorry, 4, excuse me. 3 supported it if modified and 1 opposed, and that was Consumer Attorneys of California. And I'll just say that their public comment largely related to the substance of the opinion itself, which has existed since 1998, not the edits related to the Shepard Mullen decision. So there were some modifications that were added that were responsive to the public comment. Mostly those from the Orange County Bar Association, clarifying when the PEC decision would apply and would not apply, because it was added as a reference in this as well, just as part of kind of updates with recent case law. And so the PEC decision was kind of moved into as a footnote as opposed to being in the body of the opinion. I can certainly walk through all of the edits if the group thinks that's helpful. You're seeing them on your screen in red line. But largely this was, very minor edits responsive to the public comment that we received. And there's nothing substantive that would need to require this to go back out for public comment, in my opinion.
Is the I'm just looking at the red line, the determination of whether an agreement is void requires a detailed legal analysis.
That's 3.
Was that part of, I'm sorry?
Oh, sorry, I was gonna say it's 3, line 388.
Yeah, or 3, well, I have 377. Wait, yeah. On the clean version. Yeah, right there. Oh yeah, you're right. Okay, so that's the red line. Was that the result of a public comment?
No, that's an addition that has existed within it. So nothing was changed. I'm trying to just I don't know if you can hover over the change, Angela, but I believe this was in what was issued for.
Oh, before, okay.
No, it wasn't. So this came back after public comment. I apologize. So I believe this was just to clarify this point here, and let me find it in the version I'm looking at where it talks through the public comments. Bear with me for one moment. Okay, yes, and that was responsive to the public comment. I believe it was Orange County that was just seeking clarity that what constitutes an ethical breach that would void a fee agreement would be beyond the scope of this arbitration advisory.
Okay, because I think this is I think that I don't have any other substantive comments on it, but it kind of relates to the in-house counsel opinion, the other one that we'll be talking about later today, which is whether or not you can void a fee agreement based on an ethical breach. And so anyway, I just wanted to think about that a little bit more. I don't have any substantive comments or changes. Does anybody else have any input here? Should we vote it out? Yes. Do I have a motion?
Make a motion to vote it out.
Second.
Second. Okay.
Sorry, that was
Angela?
Bill with the motion and Dan with the second. Thank you.
Okay, I'll take the vote. Ali,
Yes.
Brown,
Yes.
Coleman,
Yes.
Guzman, Mercado,
Yes.
Mohebi, Munoz,
Yes.
O'Reilly,
Yes.
Poindexter,
Yes.
Ravi, Riley,
Yes.
Chivers.
Yes.
The motion carries. Thank you.
Excuse me. Okay, let's move on to the symposium. Erica.
Sure. So this is just a real quick update for everyone who is not a moderator. So the symposium is scheduled for April 25th. Even if you're not a moderator, we certainly encourage you to attend. It's a great opportunity to get 5 hours of MCLE credit. The moderators have been working very hard behind the scenes to obtain speakers for their particular panels. And the registration as well, the opportunity to register has been posted on the State Bar website. So you can certainly do so. You can circulate it as well. It's limited to 3,000 attendees because that's the ability of our license to handle that many attendees. We typically don't get that many, but just in case. And the speaker bios and the actual speakers themselves will be posted as soon as we have them. But we're really in good shape here. Moving the symposium a week may have helped, but regardless, we're in good shape because we have over a month to go and we have pretty much everything ready. So for those moderators, you have been getting emails from Angela. We appreciate your responses to them, and we'll be starting to ask for the substantive materials soon so that we can, format the slides and get them ready for distribution and presentation at the meeting.
When is the I mean, I think it's probably already passed, but we're still working on getting our final panelist.
Yes.
So what's the grace period there?
The grace period is as soon as possible. Thank you very much.
Okay.
No, we're okay. Again, we've posted the topics themselves, but we recognize that it can be challenging to find panelists. As we discussed when we were trying to schedule and then reschedule the symposium, there's a lot of spring breaks and things happening at this time of year. So, we just appreciate your working hard. If one group has reached out to us hoping for speakers, and we are working as well to locate some of those speakers, although they found one in the meantime. And
yeah, I mean, we're looking for a federal judge, and we've got one that I think we've reached out to. Judge Yu, right, is our one of our panelists, but the other one is it's Judge Vogel. Fogel, right, Vikita, right.
Yep.
So we're working on that.
great.
Did somebody talk? Sorry. No.
No, I just agreed with you.
Yeah. Okay, we'll work on it. Does there anybody else have any issues with the symposium? Any questions? Any of the moderators? Okay. The next item is moving right along. Well, we're supposed to take lunch break, but it's only 11:30. So we're just going to push on through, right? Yes. Okay. The judge's safety article. Did everybody have a chance to read that? Carrie did some really great revisions to it. And it was originally drafted by Deepika. And I think Carrie, I don't mean to put you on the spot, but do you want to explain your revisions? I thought they were really great, and I think it's ready to go out to be posted.
Sure. I just incorporated a couple of recent State Bar decisions that I thought were topical and kind of highlighted the contours of what we were trying to do here. So and also they're kind of fun to read, and so for people who maybe are not following State Bar decisions, I thought that this was a good way to get some recent interesting decisions in front of some extra eyes.
Yeah, I mean, my own, well, I don't have a concern about it. I think it's really good, but it does it basically tells lawyers what they can, what they can't do, but also what they can do, I guess, is sort of my veiled concern there. But that's, that is the nature of free speech. So I think it does accomplish what we want it to accomplish, so that they are educated on what the law is, and, not you know, that lawyers think first before they post or make public comments about judges. So,
And also
those-
by not completely ignoring some of the free speech protections that are afforded, I think by acknowledging that there are some, it will keep maybe someone from reading this and being like, this is wrong. I have free speech. And so this at least acknowledges that there is a right, but that it's limited. And then it highlights precisely how it's been interpreted in recent decisions. So
yeah.
that was also sort of my thought, was like, somebody won't just dismiss this out of hand now, thinking that just no one has thought about the First Amendment.
Right. Yeah, and that there are, yes, there's a history of discipline cases, and you know, this is a real thing, and it's, you know, this isn't just a scare tactic or whatever, you know, this is just, you know, pure education. So yeah, I mean, I think it does it's substantive, and you know, it provides critical guidance. I actually, Erica, did you circulate the comments on the rule revisions? And if you did, yeah, so we don't have a chance to go over those yet, right? I'm just
That's
curious.
correct. It's still pending. I'll just say I have reviewed them all, and there's nothing, there's not a lot there yet. How's that? Some of them are, the comments that we've received don't actually provide comment. They just say they oppose or support and so
I
forth.
see. Okay, so there's no reason to withhold this until we get more I mean, I think this should go out, and I really want it to go out before the symposium, because we'll be speaking on it.
The only thing I'd
Go ahead.
say is with the draft, you'll want to, if you can scroll up, Angela, or down, wherever the pending rule proposed language is. We would just, you know, once there's been action in this space, this could certainly be something that staff does, but we would modify the sections that address the proposed rules to either indicate that there were proposed rules that for some reason didn't move forward, or that the proposed rules, like the changes, the fact that there are now rules and so forth. So if you're comfortable with staff doing that, or we could also bring it back to the committee when that does happen.
Okay, yeah, I mean, because this will be up, so we would just,
Correct.
it's a, you know, it can be a not working document, but a modifiable document. Eleanor?
When does the public comment period close?
April
The
15th.
15th? Yeah. So we'll be able to address those at the May meeting.
And I'll just, sorry, apologies, but I'll just add that this is just the first public comment period. So when it does go to the Board of Trustees, assuming again, it does go to the Board of Trustees, they would be required to issue it for a public comment period as well. So we would just be looking at this article and making tweaks to it essentially as it moves through the normal processes.
Got it.
To reflect whatever, wherever it is, whatever the language looks like and so forth.
Okay. And where does it go on the state bar? Like, I mean, I know we, you know, people who are subscribed, right, to the state bar, and you get an email. But where does it go on the website? Just public PR?
So a few places, there's an ethics page on the State Bar website that's where the opinions and other information related to COPRAC and ethics more generally exist. There are also, we do have some articles still on our page. We have a judicial ethics section, but I don't think that's the right fit. This is really attorney ethics, not judicial ethics. So there's no like particular topic area at which this would go. What we did for the practical guidance for attorneys on AI, which is not the same as this, but the closest thing that this committee has done in recent times, was even though it's not an opinion, it was posted as recent practical guidance on the opinions page. But we would be basically looking and working with our communications office to determine the best placement for this. Including possibly supplementing existing pages and so forth.
I'm wondering, like, can we put it under, can we request that it be put under what's new? I mean, I know there's a lot of stuff going on at the state.
Another option is there's a attorney civility and professionalism page, so that's probably the closest fit right now, at least.
Yeah.
That would address this. And that page, if there are rules of professional conduct that are ultimately adopted, I see Kathy smiling. She's probably thinking the same thing. That page will certainly be updated and reworked, but at this time, there's those are pending.
Yeah, okay. So yeah, I just want to make sure that it's somewhat prominent, so that it gets the attention that it deserves.
And there would be outreach. I mean, there would be probably a release of some kind. It would be posted on social media, and whenever we just had an all licensee email that was sent out earlier this week, but at the next opportunity that's sent out, it would likely be included as well.
Yeah, that makes sense. Okay, so do we, any other comments? Raquel, sorry, you have your hand up.
I have one thank you for adding the social media in here. And I thought overall it was a very effective alert. I did have a question about 139 and 145, which Eric, I think you began to speak on. Was it meant to be a placeholder? Which is about the rule? Because my question was like, why is that in there? Either there is a rule or there's not a rule. If there's not, just take it out. So 139 and 145. So I just think I understood you to say the rules you're still waiting to see them.
Yeah, so I mean, I think this is accurate in the sense that the committee is considering amendments to the rules right now. They've been issued for public comment, but the committee hasn't voted to adopt rules or recommend the adoption of rules. So we could tweak this. I think, with whatever outreach is done regarding this article, we would certainly include the fact that those rules are pending and public comment ends April 15th, assuming that this is approved by the committee right now, and that would be part of the distribution. But what I was mentioning is once the committee is no longer considering those amendments, be it because they decide not to move them forward or because they have been approved by the committee to be sent to the Board of Trustees, this section 139 to 145 that you're seeing on your screen would just have to be, it'd be the most living section of this document and would need to be updated from time to time, depending on where those rules are. And then ultimately, if the rules are adopted, obviously, we would be looking at probably modifying this article or just making the fact that there are rules that address this more prominent. And that was
okay. So I think I understand you to say your intention is to keep it in. And when I read this, I thought, well, we're making an alert and we're being very specific and we're not talking about rules and there aren't any rules. So why are we adding it? But it sounds like you're saying your thought is you need to notify people that there could be rules in this alert.
Yes,
I understand you.
I think Cassidy and Vikita have been at a lot of these meetings, so I would, encourage them. But I believe that the thought of the COPRAC working group, as well as the individuals from CJA who were collaborating with COPRAC's working group, was that rules take a long time. And there's a more urgent need to get information about these concerns out there before the rules will ultimately be adopted. And that was the goal of the article, was to alert people to these concerns while rules are being developed to accomplish a more
robust.
Yes, thank you. Way of addressing this.
Okay, I understand. I also noted that ABA has, I don't know if it was a letter or just a media statement on this topic. So it may be, I don't know if the committee looked at it and decided not worth noting it as a footnote, as a reference point, but as they seem to focus on the very things this alert talks about. And it's been, since January. I see something in December, but there's been something in the last couple of weeks.
Well, that's a good point, Raquel. But there's been a lot of, articles, and I know, I think you're right, the ABA did come out, and then the legislation. Maybe can we do like just links in the, like a resource page, when we post this. So, like other information, like we have like the IT opinions, you know what I mean? On the State Bar website. So we can just link to various articles and the federal legislation, or article on a federal legislation that deal with this issue.
We can, the problem with links is that we have to continue to update them. So oftentimes links, die or they get moved, and if the legislation is no longer pending. So we could certainly do that. I just would want to be thoughtful in doing so, because it's work for certainly COPRAC staff, but it's also really work for our communications team to have to deal with links.
Yeah, the stuff I know, because I was so angry at the bar the other day, the website, because there was a link to the form, the fee agreement forms that didn't work, and I'm like, why do you have a link that doesn't work? So, okay, again, good, fair point. So maybe well, I don't think we need, do we have a cite to the ABA article? Or can we vote it out and then add it?
Are you talking about the rule of law articles they've issued over the past? They did one in February, one I think earlier, like last week or so. Is that what you're referring to, or something?
You mean the statement? No, because that's not really about judicial safety as much. You mean the statement about? Yeah, I don't know.
Yeah, mine was about judicial safety. Mine was
Say that again?
a comment, and I thought I pulled it in.
Yeah, we sent
it. Yeah, but I didn't pull it. I mean, I couldn't find it. But yeah, it was their statement. It was about just judicial safety. That was more firmer than the first one they put out last year.
Yeah, I'm just Googling it. I'm wondering if we can just.
That the ABA rejects efforts to undermine the courts and the legal profession. That was the March 5th one.
Yeah, but that's not about judicial safety, right? That was just the statement that they just put out about the rule of law
and corrupt judges and so forth.
Yeah, but there's a Judicial Security Committee of the ABA. I'm looking at here.
There is a January one from Chief Justice Roberts about judicial threats.
Right. Yeah, but that's not the ABA. So there's that.
Yeah, there is that one, which was in the annual report, right, Dan? That was in his annual report, yeah, which was also.
And then there's, if anybody wants to look at that.
Yeah.
That was in his year-end report, right?
That was, the year-end report. Yeah, I also saw that.
And that one was circulated. Raquel did send that to me, and I circulated it to the working group.
Should we put that in a footnote then in the let me see here. And then there's also resolution 516. During the 2024 ABA annual meeting, the HOD, what's the House of Delegates, adopted the Judicial Division's resolution 516, urges Congress to pass they did. Was that passed just last year? 2024, the federal legislation, or similar legislation. I'm just trying to see if there's anything. Oh, here's, oh, look, the Judicial Security has compiled articles. Okay, there's a whole, okay, so the ABA has a website entitled Judicial Security Articles, but it looks like the most recent is 2023. And it has to do with cybersecurity. Oh, so maybe it's not secure.
So I'll just, this is a article that's going to be posted on the state. So we could certainly work with our communications team to consider if there should be articles added and those types of things. I'm not sure that the committee needs to look through.
Revise it.
Yeah.
Okay, so let's vote it out to be posted, and then if we want to, we can have staff update either the page, or we're gonna be able to update the article anyway based on the comment, the rule revisions and things like that. So we should be able to add any references to new articles that come out on this issue if we deem it necessary. Okay, so is this a motion? Do I have a motion to vote it out to be posted?
I move that we vote out the ethics alert for public comment, what is it for?
Not to post, for public
post.
dissemination,
For public,
yeah.
for posting. All right.
I second and thought it was really good.
Okay, I'll take the vote. Ali,
Yes, please.
Brown,
Yes.
Holman,
Yes.
Guzman, Mercado, Mojabe.
Yes, Mercado.
Thank you, Eleanor. Munoz,
Yes.
O'Reilly,
Yes.
Poindexter,
Yes.
Ravi, Riley,
Yes.
Chivers.
Yes.
Motion carries. Thank you.
Okay, let's move on. Okay, in-house counsel opinion. So the other in-house counsel opinion, 21-0003, business transactions with clients. And I'll present that. Do you want to put it up? Yeah. Okay, so I think the last meeting, we we're very, about 85% close to voting this out. I just needed to make a few revisions to it and review it with the working group, which we did with Dan and Nima, and who took who did the first set of revisions, and then I did the last set of revisions. Let's see here. Can you scroll down, Angela? So, okay. No, keep scrolling. Sorry, keep going. No, go down. Sorry, I misspoke. So just to refresh your memory on this one, this is when stock is being offered to in-house counsel as part of their employment agreement. And the question is whether or not Rule 1.8.1 regarding business transactions with the client applies. We had circulated this one originally for public comment. The original version, basically said that the rule would not apply in certain circumstances, namely when it's part of a standard employment agreement, as opposed to when the attorney is, forming a company with other shareholders or partners, and so we kind of grappled with the distinction between those two scenarios, and after the comment period and reviewing the comments, it was more clear that there is no exception to this rule, and that's kind of what we came down to with the working group, is that the rule applies, and it's actually not difficult to comply with the rule, and so those are the substantive revisions that we made, and then there was just a few minor revisions. So scroll down and I will discuss what I did. Okay. Keep going. Okay, stop. So the revision here just discusses basically why there's no exception, for situations where the employee-employer relationship sort of dominates the, remember the in-house lawyer is kind of wearing two hats. They're an employee And the relationship is more employee-employer versus attorney-client. And so, the thought was, well, Rule 1.8.1 doesn't really apply when they're wearing the employee-employer hat, because the company, the employer is, has the advantage in that relationship. Whereas under the attorney-client scenario, attorney-client relationship, the attorney, the opposite is true. So, but that doesn't really matter, because the rule is prophylactic. You have to comply with it when you are taking an ownership interest in the client. And that's what, there's no exception for different scenarios. So that's sort of the revision I made here. And I found a quote from the fair. I went back to the fair case and found that quote. Scroll up a little bit, Angela. Okay. Where it says former rule, or Rule 3-300, which is 1.81, absolutely prohibits a member from entering into a business transaction with the client or knowingly acquiring a pecuniary interest adverse to the client. So, that's basically support that it's an absolute rule. There's no, there's really not a whole lot of wiggle room, at least in California, even though there was outside, there was case law and other support in other states. We just don't have the support here. And then scroll down. Let's see, what other change did I make? I put all of, the other thing was just more structural. All the outside and the ABA discussion, I put in a footnote. The task force commentary, basically the ABA task force article that we quoted. It's not even an opinion. It's sort of just an article. So I thought that it should be relegated. All of that should be relegated to a footnote to point out that there is support for that the rule does not apply in certain situations, and that, maybe, I mean, the implication is maybe the California law will change through the courts, but we don't have the authority. And so it sort of, shows that there is, some states have taken it up and made the distinction between, the two types of scenarios. So that's it. I hope you guys had a chance to review it. Let me know if you have any comments, questions. And then I think it's ready to be voted out. I don't have any proposed revisions or changes. Bill, are you talking? Sorry.
No, I'm talking to myself.
Oh, sorry. Eleanor, go ahead.
Is this one where we could solicit comment from specific groups like Association of Corporate Counsel or others? It seems to me like one where we might want to target in-house folks and get some feedback.
Well, yeah, I mean, sure. I mean, I think we can do the same kind of thing, but I think we already tried to do that, frankly. And we, in-house lawyers, we're not paying attention. Although, yeah, I mean, I advise companies and in-house lawyers, and I try to shove this in their face and, to give me their, their informal opinion about it. So, I try to do that with clients. But so I don't know. I mean, we can try, but I would, yeah, I would support putting it in the, the intro paragraph to solicit specific input from in-house lawyers.
Is it ever appropriate for us to reach out to those organizations, Erica, or like look for the direct email or send it to someone?
Yeah, that's typically how the direct outreach works. So we would be contacting the president or whatever chair, depending upon how the organizational structure is, and sharing it with them.
Well, right. And so
it's pretty onerous. I think we should really try to make sure we get as much comment as we can.
What about reaching out? So the Association of Corporate Counsel, is it Corporate Counsel, the ACC?
That's what I was suggesting. Yeah, exactly.
Yeah, I haven't. I used to be a member. Is anybody a member? I used to be a member. I spoke at their conference many years ago. Yeah, so I don't have any contacts there, but if Erica, is there a way that we can reach out to them specifically to have them issue comment? Okay.
We can
Emil,
ask.
sorry.
Yeah, we can.
Yeah,
invite
make them
to.
issue
Yeah.
Well, I think they would have an interest in it, because you're right, Eleanor, I mean, let's see if they can come up with a way around the rule that's, complies with the law. Emil? Oh, you had your hand up, or no?
Yeah, I was just gonna ask to have that consent change, but I think Angela already did it, so yeah, thanks.
Oh, thank you. Okay. So yeah, I would agree with having a more robust outreach with this version specifically. I mean, we'll see, because I recall that I think it was the Orange County Bar that said, we agree with the conclusions, but there's not enough support, and so now the conclusion is different. And so we'll see what kind of comment they're going to come up with. I mean, that's kind of, I'm curious to see, how this is going to shake out. And the other thing, I mean, going back to it being onerous and back to the arbitration advisory about, voiding, one of my concerns about saying, look, 1.8.1, you have to comply with it in all respects. And that means that those who are not in compliance now, what does that mean, for those in-house lawyers? And my concern was, well, what if there's some dispute and the company uses this, violation as a way to void their employment agreement? And, that's a scenario that I don't really have an answer to, other than, you have to go look at what's the criteria for actually voiding an agreement. And that's why, there's more than just the violation. There has to be, there has to be an actual cause, damage cause, and that sort of thing. But that's beyond the scope of our opinion, but we can't ignore that. And I think that might be something that would be raised in the public comment.
It might be
Okay.
worth giving, it might be worth giving some thought to whether or not there are other groups other than the ACC, like employment type groups, that might have an opinion on the policies that could be implicated.
Yeah, I mean, like the California employment, I mean, I don't know what organizations are out there, but, so if anybody has any input, please let Erica and copy me on it, and we can start thinking about it.
We can reach out to Sela and Neela. I'm not sure that that's usually, I mean, it'll be interesting to see if they comment. Usually it's not probably people at this level that they're focused on, their associational level.
Okay. Anything else? Any other comments on this one? No. Okay, well, is there a motion to vote it out for public comment? Somebody move.
I move that we vote out the ethics of in-house counsel business transactions with clients for public comment.
I'll second it.
I'll second it.
No, sorry.
Okay, I'll take the vote. Ali,
Yes, please.
Brown,
Yes.
Coleman,
Yes.
Guzman, Mercado,
Yes.
Mohabi, Munoz,
Yes.
O'Reilly, Poindexter,
Yes.
Ravi, Riley,
Yes.
Chivers.
Yes.
Motion carries.
Okay, thanks, Angela. Okay, so we have, I think the only thing do we want to go over some of the opinions that we don't really have an update on, like cryptocurrency, flat fees? Is there any update on cryptocurrency? Bill, you're here. Do you have any update on that?
Eleanor is taking the
Oh,
lead on
Eleanor,
that, but
sorry.
we
Sorry.
met. I'll let Eleanor jump in, but we met earlier or last week, I guess, was it, or earlier this week? I forget, but working on another draft of the opinion.
Was there any Angela, when we spoke, I understood that there might be some guidance around what we were able to discuss since we hadn't circulated a draft. Do we want a substantive update, or do we just want to leave it to the kind of call for assistance on the property issue?
You can give a substantive update because the topic is agendized, but we cannot like there's no opinion that was associated with it.
Okay. So one of the sticking points that the working group has encountered is whether or not it's appropriate to accept crypto or property for payment of advance fees, and how the safekeeping duty is satisfied in the context of digital assets. And we would love to have someone join the group or work with the group or give opinions on the draft that is steeped in knowledge in this area, has more experience, because we're lacking some depth of experience in this area. So if there's anybody on the committee that is a fees wonk and familiar with property and safekeeping, we'd love to get your opinion. If not, we'll share it with the group and take everyone's opinion at the next meeting. But I think it would improve the opinion for us to have somebody with more experience in that area to take a look before we circulate it. So that's the plea and that's the update. We're pretty close, but
Yeah.
I think that's the one area we're still a little bit concerned about.
Yeah, definitely.
Isn't it like very specific to the nature of the digital coin, you know, as far as like safekeeping, you know, like I mean, I could tell you what your duties are for safekeeping funds and property, but I know nothing, you know, like you would have to understand what the security issues are.
I think Nima actually has a pretty good handle of that. Between Nima and the rest of the group, I think we have a reasonable understanding that we believe it's likely possible and that risk disclosures are appropriate and like what the general risks are. But there are statements about what constitutes appropriate safekeeping in the rules. And I think how those and whether we can extrapolate and how much flexibility there is in saying this would be a good substitute for that is what we're looking for, not expertise.
Yeah, I mean, like the wire fraud, like the wire fraud stuff. Yeah, I mean, I don't know if we discussed this, I don't know if we discussed that issue in the context of this opinion before. It sounds like a familiar conversation, but yeah, I mean, that I think that would be the closest analogy is what are the lawyer's duties to protect against wire fraud in, you know, and transferring funds and holding funds in your trust account. And there's a number of ethics opinions that talk about that. There's a good one out of North Carolina that talks about, you know, your duties. So I'm happy I can volunteer and
okay. Thank you. I appreciate that. Once I get the latest draft done, I'll circulate it to the group and include you. If you would just have a look at it with that in mind and give us, is that acceptable in terms of the number of folks on the working group?
Yeah, I think you just have 3 right now. It's just, it's you, Nima, and no, Bill, Raquel, you're on that group as well.
Raquel's on the group too.
5.
Yeah.
Okay, so there's 5. So that's fine.
Okay, fantastic. Thanks,
Can I ask a question related to this? How I'm assuming there's analysis that gets you past 1.15a and the bank account comment in there.
About how to hold it and putting it
I believe, I mean, this was discussed years ago in this opinion at this point, but
that's the issue.
Yeah,
no,
that's
the issue. And I was, rather than diving into it too much right now, the question is how much can we extrapolate the bank account, like holding it in trust in a bank account, the bar having specific banks that it allows you to hold funds in trust for, and whether or not property, because it's not quote unquote funds, you know, considering it as property, if it's okay to hold that in something we view as sort of similar, maybe not insured, but similar to a safety deposit box, you know, and what risk disclosures you need to make about that. But I mean, that's exactly where we're sort of hung up.
Okay.
Like,
right.
I think that's where it got stuck last time. And then there was like a couple year gap. And
yeah.
Our analysis is that it's property. It's not funds. It doesn't need to go into the bank account, but they say how, you know, this is how you typically hold property. And we can't do that either.
Right.
So you know, I think
Do
we're.
banks hold cryptocurrency? I mean, do banks, how is it held? Like,
They
they're,
don't have
can hold,
authorized trust accounts for it. I mean,
yeah, you
Yeah.
can hold it. I mean, it's like putting on a flash drive and putting it in a safe. It's not a flash drive. It's a
The key.
digital asset
yeah,
doc, drive. So there is a comparison in terms of that. You literally have to take it off the blockchain, yeah, and have the alternate source.
but there's
Hold
more and
information.
more, oh, sorry, Raquel. There's more and more, you know, traditional institutional, you know, players in this, right? I
Sure.
mean, so like, you know,
They'll
the
probably will
investment
continue.
brokers are, yeah, I mean, yeah, so it's not so much, you know, obscure, kind of like the Wild West anymore, although I still don't understand it. And
My understanding though is for a client trust account, it's got to be a bar approved provider.
Right.
So that doesn't exist yet.
Let me, to clarify that, for an IOLTA, it has to
Sorry,
be.
thank you, yes.
For a non, for an individual trust account, it does not have to be off the IOLTA list.
That's right.
is there anything in the
And I
CTA
would
handbook that
Yeah,
that
I would
talks
assume
about?
that if you're holding crypto for somebody, it's not in a pooled account for a host of reasons.
That makes sense. So it'd be an individual account.
Be
And
segregated,
it doesn't have to
right?
be approved that way. It's not going to pay interest anyway at this point in cryptos.
Do you have any sense of how now, like in how many lawyers are actually, what the percentage of lawyers are actually accepting fees? I bet you it has exploded. That's what I'm thinking, because more and more people are using crypto.
Right.
And there's more ways of using it to pay for things. I mean,
And Nima makes a good point that folks who are transacting with these entities are potentially accepting coins, right? So beyond currency, they might be accepting tokens that are just digital assets, not quote cryptocurrency. And
see, I don't know the
one of the
difference.
questions was, if it's all property, is there even a distinction there? You know, the question just becomes, how do you value it? And so we've been down these little wormholes for a while. And I think we've decided to limit the opinion at this point to cryptocurrency, but with a footnote that says that many of the same principles would apply to other digital assets, rather than diving down the digital asset hole more generally, because I'm not sure there's a clear distinction between any of this and other property, honestly, except for the types of risks.
Right.
And it will change, right? So we want to make sure that it's, that this is a kind of a broadly applicable opinion. Okay, so do we have a plan? Oh yeah, I was gonna look at this draft. And then will you guys have it ready for next time then, the June or May meeting?
Well, I'll get it circulated
Yeah.
certainly this month, and then that'll give everyone time to comment. We'll set another meeting before May and plan to give it to the committee in May.
Okay. Okay, and so we'll okay, so that's the plan. Anything else on that one? Nope. Okay, so and we're not gonna, Brandon's not here, right? So we're not gonna talk about flat fees and termination. Okay, and I think the final thing is the work plan that we haven't really gotten to. So some work plan. The working group hasn't even gotten to the work plan. So
so you're working on it, is what you're saying.
yeah. Go ahead, Erica. Sorry.
I was going to say, it could be helpful to bring it up. I don't know if individual committee members looked at it. So between the last meeting where we spent a couple hours reviewing the work plan and modifying it and so forth, which at the time, and as you'll see posted or displayed, it was very ambitious. And so if I recall correctly, the working group was going to look at many different things tied to the work plan, but not necessarily the work plan itself. And that was including exploring what additional topics should be addressed, if any, plus how those topics should actually be decided upon or rejected, the format for those topics, meaning a formal opinion, an article, and so forth, so that the committee had some rubrics to look to evaluate taking on new topics with, you know, primacy, urgency, the static nature of the topic, and so forth. And then whether, you know, evaluating the need for public comment and the balanced against perhaps urgency in getting something out, like the judicial threats article that was approved today, and so forth. But I think it could be helpful for the group to kind of see what is on the work plan, see where we got today with things. And again, this is not something that has to be approved this year. It's just an exercise for the committee to do this year, because it's highly likely that for 2026, the committee will be required by the board to have a work plan. The board's going to, has been given recommendations, but they're going to actually take those recommendations up likely at their May meeting. So it would then go in effect for the following year.
Okay, I think that's a good, especially since we need to get used to having a work plan, we should at least go over it. And we can circle back with the working group to refine it. So why don't we start with what we did get accomplished today that's on the work plan? It's hard to. So what did we get accomplished? We voted out 2 opinions, right? Client files, trying to think. So yeah, we voted out 190004, right? Did we? Yeah.
Yeah, so what's displayed for
Yeah.
190004 is correct. So it would likely come back at June. So Ange, you could take if issued off, if appropriate, and so yeah, great.
I have a question how the dates were determined in the 1, 2, 3, 4th column.
I'm sorry, in which column, Raquel? I apologize.
The 4th.
The 4th. So what they're basically working backwards. So so if this comes back at the June meeting, it could be adopted and go as early as September for the Board of Trustees, or November in theory. But just thinking of the fact that it would likely have to go back out for public comment, it's more, to me, realistic that it would go at the February 2026 board meeting. We could certainly move it up or move it the opposite direction, but that was the thought.
Wait, so
okay, I guess when I looked at them, I felt like, okay, why are they 11 months away from now? See, it seems like an excessive amount of time. But you answered the question.
Right. So again, I think from the perspective of staff is that this is an accountability document, and so if we could certainly, you could certainly move the deadline up. It could be September. The board's going to be meeting May 2025, September, November 25, and then February 26. So the committee could certainly move the deadlines up. I recommend, since this is something that the committee is getting comfortable with at this stage, giving the committee a bit of time farther out, so that it's better to, you know, exceed deadlines than go the opposite direction. But I understand, I hear you, Raquel, that these are far away.
So can it just be the outside deadline? This is, you know, this is sort of like, you know, worst case scenario, but we could maybe get the earlier meeting if we, if this is the last round of public comment.
Do we have the working group calendar? Or on there or not?
What?
The committee,
For this opinion?
The focus group.
Oh, no. Not really.
Oh, so shouldn't we put that? Yeah, we can put that in.
1908. It's not there.
And that was to have focus group input in May, is that right? From what I recall.
That sounds right.
Okay. Anything else on this opinion? Nope. And so lawyer as expert witness, that's out for public comment now, right? Yeah, that's the one that's kind of come back on April 15th. So we're just sitting on that one. And then flat fees. That's the one, what do we have there? See, covering. Do we have? We don't have,
It wasn't talked about today.
no, but what is the response to public do we have public comment? What is the status of this one? We did send it out already. Oh, it's a 20.
Yes, it has come back from public comment. I'll work with Brandon and see if he would like staff to move forward with implementing the integrating the public comment, and I'll reach out to the full working group as well, but starting with Brandon.
Okay. And then conversion clauses. Where that's Brandon too, right? Or no, is Topeka working on that one? Oh, she is. That wasn't even on the agenda. We don't know what we're doing with that one though, right? Or was she looking at it more closely? Well, Q4 2025, that's when, what is that? What is that column? Sorry, what's the title of this second column? Emily, okay. So I think we just need to know what we're doing with this opinion, right? We don't even know if we're going to be keeping this one going. Is that still the big question? Anybody? Is there anybody here that's on the working group? No. Okay, so let's just move past that one unless you have it.
No, I am.
Oh, Eleanor, sorry.
We haven't.
Oh, you are.
We haven't
Sorry.
met since the last one, so I'm not sure. Where we
Do you
stand
want-
with getting it forward. I mean, I can give you an update. There was a draft circulated. Feedback was provided, I don't know, within the last 2 months or so. I'm not sure where it stands, so we should check in. But that it is still moving forward. And I think
Okay.
we are probably close to a consensus.
Okay, so can Angela or Eleanor just, circulate something to the working group to figure out what the next steps are?
Yeah,
And
Angela,
then
do you want to
we
do that? I provided comments in the last draft, and I think we probably need one more meeting before it's going to be final, but it is pretty close. So maybe prompt for a meeting would be appropriate.
Okay, I'll send out the latest draft and an email about that after the
Thank
meeting.
you. Are you copied on the most recent drafts?
I'm not, I don't
In the
think.
working group?
Yeah.
I can send you what I think is the most recent communication on this, so you can
Okay,
attach.
great. Thanks.
Okay.
Right. All right, and so next one is the in-house counsel one. We voted it out. So we're on track. There. Okay, keep going. We talked about cryptocurrency. Can you go back up to the in-house counsel one, Angela? Can you type in, I mean, can we, I guess my question is the purpose of this chart, we can type in notes of, like the to-do. So like here we are going to do some outreach to certain like the ACC and other interest groups or bar associations to get specific comment. Okay. And then you can keep going. Ethics of in-house. Okay, this is so this one is still on track. What was the plan for? We're just going to restructure it with the working group, the ethics of in-house counsel, and then come back for the June meeting or the May meeting to review. Okay. This one, yeah, draft. Okay, so this is me, adjacent work and retainer fees. That's still fine, I think. I don't have anything to add there. That one was voted out, right? The arbitration advisory. There's nothing more to add there. The rules are still up for public comment. Okay, that's still on track. And yep, we did that. Okay. And that's it. So we're basically on track with our, oh, there's more. What's this? Oh, this is our work, or this is the
Correct. That's
the work plan. This is this. It's like very meta. Okay, so okay, working group, me, Eleanor, Nima, and Vikita, we need to just get a meeting planned between now and say May. But maybe are you guys, is that too ambitious, or do you want to push it out until June, or how do you guys want to handle this? I think we can probably, when is the May meeting? May 9th. May 9th, so it is early. I've got a really busy April. Not that this is a
Happy to
huge
try
thing,
and do
but
it in March if you have time.
I'm sorry?
I said I'm happy to try and do it in March if you have time.
Yeah, I mean, we just need to let's just get a meeting scheduled, and we'll try to get it more focused, and something to discuss for the May meeting. So Angela, why don't let's try it again and do try to schedule a meeting through your polling thing next couple of weeks.
Okay, no problem.
Okay. Is that the last thing on the chart?
Yes.
Yay. Okay, good job, you guys. That's it. Are we done? Oh, Eleanor, go ahead. Sorry.
The public comment or the statements from the public at the outset of the meeting, that might be something we want to add to the work plan as a discussion item or an agenda item for meetings, but I thought it was an interesting comment. I often don't think that we're well positioned to respond to them, but today sounded like something that might be worth considering. And maybe as an article alert, if not a full-blown opinion, but I just wanted to raise that because I heard it and thought, yeah, we might be well positioned to comment on this.
I thought the same thing. I'm glad you brought that up, but I don't know the process or protocol for doing that. So go ahead, Erica.
So two things. The the big picture, the macro issue there is impermissible solicitation. And I'll just, for what it's worth, I think we may have talked about this at another time, but we've been, the State Bar has been doing a lot of proactive outreach tied to improper solicitation, tied to the recent Los Angeles fires.
Oh, right.
It's a very different set of legal circumstances that these two groups are facing. But there, you know, we did get a lot of feedback that there was improper solicitation occurring. And a lot of solicitation in areas that are somewhat opaque in the sense that there were a lot of education events that were going on related to the fires about knowing your rights and the legal issues and so forth. And some of those were really good, came from a good place, and were feeding people and providing just information, and others were on the other side of that spectrum and really just education solicitations that were guised as educational events. And so not to take away from the public comment that was provided, and the committee may want to focus on that particular issue, but I just wanted to raise the fact that there hasn't been an advertising or solicitation opinion in a very long time. And there are other issues related to solicitation that have been coming up more recently.
Okay, so I have a couple of thoughts there. I didn't quite understand really the issue there, though, that they were talking about, the domestic violence. Is it that the vulnerable domestic violence victims are being approached by lawyers when they're what's the scenario there?
Not the victims, the respondents who have the protective orders filed against them. So before they've even been served, they get wind of it.
Yeah.
Oh, and then they go out to, okay, I get it. Okay, so they just check the docket to see if there's been a TRO filed, and then they go out to okay.
It's gross.
So
I didn't even know that was a thing. Yeah, I mean, that's interesting. Okay. So my other thought is is this something we want to, there's members of the committee that wanted to explore, this issue, whether or not it's something that should be an opinion, alert, rule revision, whatever, can we see if we can put together a working group to explore addressing this issue, if there's interest? Yes.
I'd be willing to be on a working group for it. I used to be a criminal prosecutor, and I was assigned to the domestic violence court for a couple of years, so I have some experience with it. And I also think it's a really important issue, and I would absolutely support a change in the rule. I know it's a bit of a lift, but I think Erica said that actually it's not that much more difficult to modify the rules as it is to get an opinion out. So I think it would be worth the effort.
For this committee, that's correct. I mean, obviously the rules have to go to the California Supreme Court, and
yeah. And I think that there's also I think that this is, hyper relevant for DV victims, but I think that there are other types of restraining orders that this exact same solicitation rule could encompass. And then there's even other like civil proceedings where if you're doing some type of ex parte hearing and you're getting an injunction or something, like I think that this applies more broadly too. So it's not such like a narrow issue.
Okay, great.
I'd
So
be
Carrie
willing to be on that as well.
So would I.
Okay. Great. Okay, good. That we've got 3. Excellent. Okay, so Angela, can you send around an email to schedule a meeting for the working group on this one? And maybe for the next meeting, well, it depends on what you guys have the capacity for, but just, come up with, just present your thoughts, just a proposal for where you think this can go, whether it's not worth it, whatever the thought is,
Who was the third person who had Carrie, Eleanor, and Vikita? Thank you.
Go ahead, Eleanor.
Given that this seems to be happening now, and the issues with the fires. I wonder if we might want to consider doing an alert type publication while we consider a broader opinion or proposed rule change. And I guess I'd just like a refresher on what we're doing there, and how easy it is to add something into the mix. With respect to
Go ahead.
alerts, like if we just did a simple alert and wanted to publish it, is that something we could decide to do pretty easily and put to the committee, or?
Yes, so alerts, like the article that was approved today, I mean, that took a little bit of time, but mostly because there were other meetings associated with it related to the rules. But as far as an alert, if the committee decided to add that to their work plan today, then that's something that could come back as soon as the May meeting to be approved in theory, of course. So alerts, that's it. Formal opinions currently go out for public comment and then have to be approved by the Board of Trustees. The alerts have a disclaimer at the bottom, which you saw today, that says this has not been approved. It doesn't come with the same level of right. So that's just something to think about, but that's certainly a path that could be done to address the urgent needs. And then, possible formal opinion, possible proposed rule changes and so forth could come thereafter.
So if we were to meet and decide that we wanted to do both potentially, or do an article type of thing, would we need approval from the committee today in order to provide a draft at the May meeting?
I don't think that, I think the committee has from what I'm seeing is in concept, the committee is open to exploring this, and then the committee would.
It doesn't require a formal process. Okay, got it. Thank you.
So yeah, so you can have, the working group can come up with an article on. Do we want the working group to also include the fire, the educational presentations on the fires that as part of the scope of the issue of the working group, and then you can draft, if you can draft an alert, then you can submit it, and then we can review it right at the next meeting if you want to be so ambitious. But I think, Eleanor, it sounds like that there's a little bit of urgency with the wildfire issue, right? Because it's happening now. So I think that's a good focus.
Can I just ask a question? So the issue with the wildfire solicitation is that it's happening in person or on the phone, or what, it's like some type of in-person live contact. And we're saying that they're doing it under this like guise of presenting like know your rights and whatever, but their actual motive is to sign these people up for their services and not to inform them of their rights, and then present like a panel of wildfire attorneys, as a resource that they could like contact if they were interested.
That's what we've been hearing, correct?
Okay. It's such a weird, right? Because it like, you have to prove motive. You have to prove that like, and then there's also this like weird tendril where it's like, well, you can be motivated by money as long as it's not like your main motivation. So it's like, it's really a difficult, solicitation cases are hard. We should change that.
But it would be, yeah. It's a good
person.
But if it's, but if it's predatory, you know what I mean? Like that's kind of what sounds like this may be happening. And I think it's worth exploring, the alert for it, it's because, and it has more of like an emergency sense too. So, because it happens a lot with like life insurance, I'm trying to think, like this happens every so often where there's like a scheme to present, educational, have conferences and not conferences, but, doing these types of things. And it's really, just a way to get clients.
Dinners.
Yeah.
Different scams.
Scams. Yeah. So this isn't a new thing. It's just a new avenue for lawyers, that, and it's just might be a reminder about, the old scams that didn't work before. Okay.
For our next meeting, the working group for the solicitation working group, we should come up with a proposal or something with respect to like the DV scraping data situation. And then also you'd like us to put together a alert or something like that with respect to wildfire solicitation?
Yeah, I mean, I think you should discuss those two things to see if you guys have the capacity to do it. I mean, I think that's, really the issue. But I think those fall under the same umbrella of solicitation issues that we've discussed here, that can be part of the working group. Go ahead, Erica.
And just one added layer is that my firm is representing many, many plaintiffs in the wildfire litigation. So that's just, and I probably would just need to make sure that there's no issue from, we don't want to look like we're trying to
Right,
say,
you're competing with, right.
yeah, we're
no,
knocking
but
off
your
the
name's not gonna
competition.
be-
We're saying they're doing it wrong and we're doing it right or something like
Right.
that. So I want to make sure that I'm on record saying that we are representing plaintiffs in that litigation.
Okay. Well, I mean, it's not like your firm's gonna have it's not gonna be on your firm's letterhead and your name's not gonna be on it, but you are a member of the committee.
They don't
so.
think I'm an attorney, so it's okay.
Okay. Erica?
As in regards to the articles, so there are COPRAC opinions that have addressed these topics. There's a 2006 opinion about chat rooms for mass disaster victims. There's a COPRAC opinion about using police related information and court records and so forth to do targeted mailings for individuals, which is, a mailing is not considered to be a solicitation unless there's other issues involved. So it could be that there's a lot of work that's been done in this. It's all old, but it could be reviewing those, updating those, promoting those in some way in the article and so forth. So that may give you a good starting point. And for the working group on this, we can certainly send you those resources.
That would be great. And I think that that's the point, is that the attorneys scraping the information and mailing out letters is not actually a violation under the rules as they're currently written. And so I think that's why we might have to consider a rule change in order to. Sorry, Emil, I totally cut you off. You had your hand up.
No, thank you though. So I guess I look at the fire issue different than the DV issue. And the fire issue is like 7.3A, and then the DV issue could be advertising, but probably still solicitation, but it's not real time person to person. But I also think that how would we change the rule? And I'm not on that committee, but I want to just make sure that we think about this. Is there a court rule that could be changed instead, or should be changed in terms of having these things filed under seal? Because I also know that a lot of big law firms use court records to also solicit business to people known to be in need of legal services, but they're usually
That's
soliciting
true.
the general counsel in a major litigation, and then they do those dog and pony shows where they say, hey, hire our firm to do this. So I think it's going to look very interesting to have probably in 7.3 an exception for domestic violence cases. I just don't know how, I'm trying to think through how it would be written. So, and if that would really be appropriate, because then somebody else is going to say, what about this? I'm not saying it's not a big issue, but I'm saying is a change to the ethics rules something that should be thought of? Or is it maybe a court rule where it should be sealed? Because then part of the other issue is that the respondent is going to say, well, I didn't have the ability to get this commercial speech advertising, which is, Supreme Court said under Bates v. Arizona, is commercial speech protected by the First Amendment. So just my thought.
Maybe you should be on the working group, Emil.
Join us.
But, yeah, but those are all really good points. I mean, yeah, right. I think those are all really good points that need to be thought of. I would imagine that if it goes out for public, well, an alert wouldn't go out for public comment, but certainly the rules revisions, and there would be people who do, look at the dockets and solicit, the big firms that do that and solicit big companies that would be want to comment on that if we prohibited some of that that's now permitted. Okay, Novella.
Yeah, I think the court rule angle is interesting, but you could also have First Amendment issues with access to court records. So I think it would be tricky to figure out how to create a rule, like a court rule, that would lump together like certain types of records, given the case law about like the individualized consideration when sealing court records.
Yeah, it is hard to get court records sealed, but I don't, is there a difference? Are domestic violence matters treated differently though, you know? I mean, actually, aren't they? I mean, those are usually filed in family court, which are not really public. Isn't that right?
Yeah, that I don't know, but I also, I mean, the opposite side of it too is if we seal those court records, then people don't know that there's some person that has allegations against them, you know, so there's public protection issues by sealing court records too. So, I mean, it's not an easy, there's no easy answer here, right? So.
Yeah, we're issue spotting, but it's certainly something, I mean, I wouldn't have even thought of, you know, changing court rules when we're thinking about rule revisions, you know, maybe thinking broader is how can we accomplish what we're trying to accomplish in different ways. Okay. Sorry, no hands are up. So do we have clear direction on the working group here? Carrie and Eleanor and Vakita. Yes, okay. Okay, anything else on this topic or any other topic? No? And we're all set for, I guess we'll see everybody or people are going to the symposium at the symposium. So we're all set for the symposium, April 25th. Okay, I guess we're done here. Yeah. Okay,
right.
Thanks you guys.
Thank you.
Bye.
Bye.
And see.
Thanks. Thank you.
Bye you guys.
Have a good weekend.